This is Shinner's webinar on 5 legal cases every design professional should know. With me today is Mike Koger, who created this program and who has presented it at the AIA National Convention and through the AIA Contract Documents website. Although Mike now works for the AIA, he spent years as an architect and urban planner before going to law school. After law school, he practiced civil litigation and I'm sure gained an appreciation of the power of case law. He is now with the AIA Contract Documents program and was instrumental in crafting the 2017 version of the AIA documents for the traditional design bid build delivery method, and is now working on updating other documents and creating new contract forms for the evolving construction industry. Mike and I will discuss 5 cases, one of which was instrumental in establishing the basis of construction law, and 4 others that have had a significant impact on what is expected of contractors and design professionals. Here are the 5 cases we'll discuss today. Mike will discuss what is perhaps a fundamental case in differentiating design professions from the construction industry. At almost 100 years old, the Spearin case has basically been expanded from its initial ruling into an entire body of law that really has molded the design bid build delivery method and enables construction contractors to both limit their exposure and expand their revenue through delays and extra claims. I will discuss the Duncan case. That's a case that really establishes the obligations of design professionals to carry out their professional responsibility, irrespective of contractual language. It is the case that came out of the Hyatt Regency disaster in Kansas City in 1981. I also will discuss the Perini case, which led to a significant clarification in the AIA documents on the issue of the measure of damages for contractual breaches. And Mike will close out the program with 2 more recent cases that set some parameters of the responsibility of design professionals, the subsequent purchasers of facilities, and that define some of the risks with projects focused on sustainability. So I will turn it over to Mike to answer this question. Why do we care about old cases, or why do we study case law at all? Mike?
Well, thank you, Frank. And the question of why we care about old cases, I mean, for one, old cases are an interesting, they do provide us with an interesting war story about, some events that led to litigation in the past on a construction project. They also give us, they help us remember and understand the law, because it really puts the law into, a vivid 3-dimensional setting with real parties debating the law and debating contracts. But more important than that, old cases are really, one of the fundamental aspects of our legal system. And they do have bearing on and real legal impact on the actions of design professionals and of construction professionals today. We get, of course, our legal system from the English common law system. And the English common law system gave us a concept of what we call stare decisis. And stare decisis is something of a fancy term that really means that if one court interprets a law in a particular manner, lower courts and future iterations of that same court must follow it. That means that courts are not acting independent of one another, and there really is a hierarchy amongst our court systems that if a court, for example, like the Supreme Court of the United States, creates a decision or interprets a law in one way, even subsequent iterations of that Supreme Court with perhaps new members should be following that precedent. The English common law really placed a high importance on the idea that cases with similar facts should yield similar results. And one of the reasons that I have the 2 images on the screen right now, this is a Senate Judiciary review, a confirmation hearing of, at the time it was nominee Judge John Roberts, you see a lot of this idea of stare decisis in these kind of nomination proceedings, where senators are asking a presumptive nominee, whether or not they are going to be holding on to and will they be honoring judicial decisions of prior iterations of Supreme Courts. So let's look at the hierarchy of the courts in the United States. We really have two different court systems in the United States, at least two different main court systems in the United States. On the right side of the ledger, we have state courts. On the left side, we have federal courts. State courts are courts of broad jurisdiction. You don't have to have a special reason to be in state court. These are courts where you're going to find most family law matters, most criminal law matters, and certainly matters dealing with contracts and business dealings. So you will find most of your construction law cases and disputes being resolved in state court. And state courts have typically three different levels. You've got a trial court, and then appeals court level, and then the state Supreme Court. And of course, having jurisdiction over all of those is the United States Supreme Court. So it is entirely possible for a case to originate in a state trial court and make its way all the way up to the United States Supreme Court. On the other side of the ledger, you've got federal courts. I won't talk too much about those, but they do exist. You can have a construction law case in a federal court, but you really have to have a federal reason to be there, whether or not you've got parties from different states or you are dealing with some particular type of federal law. They're courts of limited jurisdiction, and so you'll have fewer construction law cases will end up in federal court as a result. Again, all of those courts will find their way under the jurisdiction of the United States Supreme Court. So that's something to keep in mind as we go through these 5 cases today. We're going to take a moment to point out, what court made these decisions, and we'll put that into perspective as to what other courts have to follow it and what other courts may look at it for precedential value.
Okay, Mike. So let's move on to the Supreme Court case.
Sure. First case we're going to talk about today is United States versus Spearin. This is the oldest case we're going to talk about, and it is the only U.S. Supreme Court case we're going to talk about. This is a case that arises out of a dispute on a construction project at the Brooklyn Navy Yard. Those of you in the New York area are going to know exactly where this is. The Brooklyn Navy Yard is a large industrial shipbuilding site that is in between the Manhattan bridges and the Williamsburg bridges, just across the East River. For about 160 years, from the early 1800s to the 1960s, this was one of the largest shipbuilding sites for the U.S. Navy. And it's got an interesting, place in history for shipbuilding construction. Built some of the most important ships in our naval history. For example, the USS Missouri is on the left side of this image, and the USS Arizona is on the right side, just below the waterline. And that, of course, was attacked during the attack on Pearl Harbor. So let's talk about this dispute. Spearin was hired by the U.S. Navy to build a dry dock at the Brooklyn Navy Yard. A dry dock is exactly what you see in this image. It is a staging area. It's a large staging area for the construction of ships and warships in this instance. Spearin was given by the U.S. Navy a set of plans and specifications, and those plans and specifications called for, amongst other things, the removal and relocation of an existing sewer line that bisected the site that would eventually be the dry dock that Spearin was going to build. Now, Spearin went ahead and complied with the plans and specifications and rerouted the sewer line around the site where they would be building the dry dock. And as soon as they started constructing the dry dock itself, the New York area got a series of heavy rains, and the sewer line backed up. There was internal pressure on that sewer line that was relocated, and it flooded the entire site. Spearin stopped work on the site and told the Navy that they were not going to finish work, and they're not going to continue doing work until the sewer line was fixed, until the Navy came up with a way to fix it and hired either them or someone else to do it, because they considered it to be a menace to the workers who were working there at the site. Now, the Navy weighed their options and ultimately terminated the contract with Spirin. And as you can imagine, since we are talking about a case here, Spirin ended up suing the Navy for a certain amount for unpaid work that they had performed and also for anticipated profits that Spirin had not been paid for their work. Now, the Navy made a series of arguments to defend against this claim. You know, they argued several things based out of their contract with Spirin. They argued that Spirin was supposed to examine the site to make sure it was suitable for the work. They were supposed to check the plans against the site conditions. If they would have done those things, they might have known that the Navy's plans and specifications had a problem and that they couldn't perform as intended. And also the Navy made the argument that that Spirin was responsible for the quote-unquote entire project until the Navy accepted it as complete. Well, here Spirin was trying to turn it over back to the Navy while it was not complete. And Spirin made a much more simple argument to pursue their claim. They said, made the argument that, hey, the plans and specifications you gave me were defective, and I complied with them. They didn't work, and it is up to you, Navy, U.S. Navy, to rectify that situation. You can imagine who wins this case. We call it the Spirin Doctrine for a reason. Spirin ends up winning this case, and it's kind of a good tip that if you ever find yourself in a dispute in which you are making the more convoluted, more hard to understand argument, like the Navy is in this instance, it's probably the losing argument. So the Supreme Court gives us this rule that we have been talking about in construction law circles for the last 100 years. And I don't usually read from slides, but this is probably the most important language we're going to talk about today, so I will. The Supreme Court said, if the contractor is bound to build according to plans and specifications prepared by the owner, the contractor will not be responsible for the consequences of defects in the plans and specifications. This responsibility of the owner is not overcome by the usual clauses requiring builders to visit the site, to check the plans, and to inform themselves of the requirements of the work. And this gives rise to what we now know as the implied warranty of adequacy. I'll talk a little bit about more of that in the next slide. So that seems like kind of an obvious resolution to that case. So why does it matter so much, and why do we still talk about it 100 years later? Well, courts have been, reinterpreting and considering the Spirin case for the last 100 years, and it's given rise to quite a substantial amount of construction law. One thing that is important to point out is this case says that an owner provides this implied warranty of adequacy to contractors. It does not say that, and it is completely silent as to what kind of a duty or what kind of a warranty or anything that the architect might be providing to an owner or to a contractor. Most of you architects and design professionals who are listening, you know, and you have probably been counseled many times that you should not be providing a warranty on your projects. In fact, you are to perform up to your standard of care, and that is about all that you can get professional liability insurance coverage for. So that's one of the dynamics that has shaped law over the years, is that owners owe one duty, architects typically owe a slightly different duty, and owners continue to try and push that duty down onto architects in their contracts and in other types of project delivery methods. Another thing that is interesting about the Spirin Doctrine is that it doesn't exactly apply, certainly not in the same way as to design-build projects. There have been a series of cases which examine the Spirin rules in the context of design-build projects. I've seen ones in which the design builder is now providing a warranty to the owner. Because, of course, the owner in this instance is not actually providing plans and specifications to a contractor. You have a design-build entity that is taking some criteria from the owner and developing those plans and specifications further. And one more note, and I know Frank's got you have a few things to talk about in regard to Spirin here, but Spirin can, in the case with, from the Brooklyn Navy Yard, it's interesting to point out that that Spearn used this, or they made the argument to get anticipated profits that they should have gotten, and to get paid for work they already performed. But over the years, the same logic in that case has been used to assert delay claims, defend against allegations of defective construction, and to seek compensation for extra work when plans and specifications are in some way alleged to be inadequate. So it can be used quite a few ways by contractors to defend and to assert claims as well.
Yeah, I think that's very true, and the construction attorneys have really worked hard over the close to 100 years to expand what Spearn really means, so that it's not just that the contractor will not be liable to an owner for a loss or damage resulting solely from the defects or deficiencies in the plans and specifications, but turning it into a source of other claims, such as the delays and extras. And Mike also mentioned that in design build, it really should be reversed. But for those of you who have worked as subcontractors to design builders, you have probably seen in contracts language that really tries to move that warranty obligation onto you. The consensus docs design build agreement, which we see a lot of, tends to do that. It tries to make the architect or the engineer responsible for the adequacy of the plans as an implied warranty, much in the same way that owners have in a design bid build situation. And certainly construction contractors who write their own design build agreements do everything they can to try to preserve their rights or the rights they think they have under the Spearn doctrine. So you need to be very careful when you're looking at a subcontract agreement to do design build, that you're not taking the role of the owner in on the adequacy of the plans and specifications. Okay, let's move on to this case. The collapse of the Hyatt Regency Skywalks killed 114 people, injured another 216, and it remains one of the most significant events in the construction industry of the 20th century. And it really was a turning point in terms of industry awareness of the critical role of shop drawing, the shop drawing process, and what design professionals have to do with shop drawings. This is the Hyatt Regency. The project owner was a Crown Center Redevelopment Corporation. That's basically Hallmark Cards, the green card manufacturer. They hired a project manager to act as the owner's representative, hired Edward Larrabee Barnes as a master planner for the hotel project. Two local Kansas City firms, Patty Burkbile Nelson and Architects, and Duncan Moore and Lefevre Architects, were hired as the project architects to prepare the hotel design and to perform contract administration duties. This is a 45-story hotel, has a nice revolving restaurant at the top. The architects subcontracted the structural engineering design to Jack Gilliam and Associates, the St. Louis firm, and that was part of a company called Gilliam Colaco. After the Skywalk collapse, the firm changed its name to GCE International Inc., and we'll refer to it as GCE in here. The engineering firm's base contract fee was about $247,000 for the structural engineering portion, and the total project was $50 million. The firm's founder, Jack Gilliam, was a structural engineer of record, and he was president of Gilliam Colaco, and he sealed the structural drawings, including the sheet that contained the skywalk details. This shows a little diagram of the skywalks. If you think about what that hotel tower was, to the south of that hotel tower are restaurants and ballrooms, kind of a function block for the hotel. And in between the tower and the function block is this 4-story glass atrium was 120 feet wide, and it was a lobby and a registration area for the hotel. And they get hotel guests from the tower to the function block with having to go down to the ground floor and through the lobby. The architect designed a system of 3 skywalks or sky bridges suspended from the atrium roof steel at the 2nd, 3rd, and 4th floors. The bridges were meant to be light and airy. They had glass handrails and thin steel rods that suspended them from the above the atrium floor from the atrium steel. The bridges spanned the full 120-foot gap between a tower and a function block, and they hung from the roof by these 1 1/4 inch diameter steel rods that were placed at various intervals. The unique feature here is that the 2nd floor bridge hung below the 4th floor bridge, sharing the same steel rods that connected both the skywalks to the structure above. That's what the original design was. The idea was that the 4th floor bridge would latch onto a rod at midpoint, and the 2nd floor bridge would hang from the bottom of the rod. And the 3rd floor bridge was offset and hung from its own set of steel rods connected to the atrium above. And here's the problem. It's not something you can design, you can build from the design very well. It should note that in the decision, Missouri licensing law requires that the corporations that practice engineering designate responsibility for all engineering work to one individual. That's the person whose name is listed with the licensing board and who signs and seals the document. And Jack Gilliam was designated by the company as the engineer in responsible charge of the firm's engineering work. He had a young structural engineer, Dan Duncan, who actually prepared or supervised the preparation of the project's structural drawings. And Duncan is the one who reportedly designed the single rod concept and then eventually approved the fatal change to the 2-rod connection idea. This is how it was supposed to work. The problem, of course, was that the rod had to be continuous and smooth and yet have a threaded connection for the hex nut and washer to hold the upper skywalk, something a fabricator can't really do very easily with because the threads have, it's one diameter of that steel rod. There was efforts to refine it, and this was one of those projects that was fast-tracked. The construction contract was issued in February 1978, but the architecture and engineering drawings were not issued until August of 1978. The framing plans by the structural engineering firms were issued for review, showing the 2nd and 4th floor skywalk framed by box beams made of 2 channels, and full length of the bridge, 120 feet long. And the structural drawing noted that the box beams were connected to 6 1 1/4 inch diameter rods per walkway. And these structural drawings were sealed by Jack Gilliam. In May, the structural details were again issued for review, and in August, they were finally issued for construction of the atrium A section. The documents that were issued referred to a critical detail leading to the eventual failure of the system. Here's what ended up being built. The original design was prepared by Duncan and called for the 6 continuous 1 1/4 inch steel rods connecting both the 2nd and 4th floor walkway. And therefore the weight of both walkways would pull down on the rods from the atrium steel. During construction, the steel company, the steel fabricator, proposed that the single rod be changed to a double rod assembly, the one on the right. So the rods would actually be split at the 4th floor box beam. The fabricator submitted these shop drawings of the connections, the revised connections, to Duncan. He approved them without reviewing the 4th floor box beam connection. And as you can tell, by offsetting the rods and creating a two-rod system, that would eliminate the need to thread the entire length of the rod, and would only require threading the top and bottom 6 inches of the rod. This clarification, the testimony says the steel fabricator called the steel detailer back with a modified design for the two-rod system that has been approved. And the effect of the change is quite obvious. The load was doubled on the nut and washer supporting the 4th floor walkway, and that became the critical area of failure. Actually, let's give you some of the shop drawing review stands. The shop drawing review process worked actually as it was planned to work. The fabricator asked questions of the engineer, the project architect, and Gilliam's own reviewer all asked questions about the design change, and at least 4 different people detected a change in the submittal. The problem was that the process failed in its reliance on one person, the design engineer, who did not perform a simple and critical calculation to check the strength of the revised connection. So the process was okay, and the licensing board found that, but the court found that one person in that chain of command failed to do his job. The steel shop drawings began a review process as required by the contract documents. It's interesting that they were stamped, received, and reviewed. Their shop drawings were forwarded from the general contractor to the design team, received by the structural engineers. A technician for the structural engineer was assigned to check the shop drawings. He was not a licensed engineer. He noticed the change from the original single rod design and talked with Dan Duncan, who was the PE who actually designed the original setup, about the change. Duncan said that he had been in contact with the contractor, understood that the contractor could not make the walkway system with one continuous rod. And the testimony at the disciplinary hearing stated that Duncan told the technician that 2 rods was basically the same as the 1 rod connection, and certainly a misstatement. This is what it looked like when it first opened, with the arrow pointing to the 4th floor walkway. The 2nd floor walkway hung below that. The one closest to you is the 3rd floor walkway, which is independently hanging from the atrium ceiling. This was a popular area in Kansas City, and just about a year after it opened, they had something called a tea dance, kind of a formal dance. And during that, in 1981, the 4th floor walkway gave way, causing it and the 2nd floor walkway to collapse onto the lobby floor. 70 plus tons of debris crashed to the lobby floor. 114 people were killed, some instantly, some before they could be rescued. Over 180 additional people were injured. It took, in fact, over 14 hours to remove all the debris and rescue the last victim. The 3rd floor walkway, of course, not collapsed. It was later removed because they were worried about the high probability of failure during the life of the building. Now, the National Bureau of Standards in Washington did a study of this, a major report. That's what's now called the National Institute of Standards and Technology. And it reported that in terms of loss of life and injuries, this was the most devastating structural collapse ever to take place in the United States as of that time. This picture, that's the collapse, and this picture really tells the story of what happened. The nut washer holding the walkway simply sheared through the box beam assembly. Because the support lacked any redundancy, failure of the one connection caused the entire walkway system to fail. much has been said about the case over the years. And there are some that said that the licensing board was simply looking for someone to blame, and there are others who thought that revoking the engineering license was not enough punishment. So this case really is relevant not so much in the outcome, but in how the court arrived at the decision. This is illustrated by looking at 3 of the 7 holdings of the Court of Appeals. These are just paraphrased from that. The structural engineer's duty is to determine that the structural plans which he or she designs or approves will provide structural safety because there's a strong possibility of harm that existed. And what they found is that there was total indifference to this duty and therefore indifference to harm, and that's gross negligence. So what they found is that both Duncan, the engineer, and Gilliam, who was responsible for Duncan, committed gross negligence. Even though it may have been customary practice to delegate some of the design, that's not a proper defense to a violation of a statute, because engineers and architects often have a non-delegable duty of responsibility when you sign and seal something. Relevant facts. Duncan, the architecture firm contacted Duncan to verify that the double rod system was structurally sound. Duncan advised them it was. The records of GCE, the structural engineering firm, contain no web shear calculations of the connection. Duncan actually acknowledged that the web shear calculations were necessary to verify the structural soundness. The firm's internal procedures called for a detailed check of special connections, including shear calculations. But it's clear that Duncan did not review the box beam shown on the shop drawing. That was reviewed by the technician. And Duncan did not confirm compliance with the building code. And for Gilliam, he had a special role, because one of the problems at this point in time, for those of you who know a little bit about history, the Kemper Arena roof collapsed. It was a long-spanning construction in Kansas City. It collapsed. After that happened, the owner of the Hyatt Regency during construction asked that the structural engineering firm look at the atrium, and in fact, before they could, part of the atrium of this hotel collapsed. It was clear that workmanship was the cause, but the owner paid the structural engineering firm an additional fee to check the entire design of the atrium. And Gilliam assured that the owner that he personally reviewed every connection in the hotel. It stated that the firm checked the suspension bridges and found them to be satisfactory. And Gilliam said in a meeting with another engineer that he had run a detailed, thorough reanalysis of all the atrium steel. So, here's what you have. You have Duncan committing gross negligence for failing to review the shop drawings and misrepresenting to the architects that the double hanger system was safe. Gilliam was vicariously liable for the responsible acts of Duncan, who worked for him. He was also found grossly negligent because he failed to review the designs before fixing the seal. So, gross negligence is an act or course of conduct which demonstrates a conscious indifference to professional duty. And the state appeals court affirmed the finding of gross negligence of both Duncan and Gilliam, and the firm was vicariously liable for their gross negligence. It's interesting they started pointing fingers. They claimed it was custom for the fabricator to design some of the structural steel connections, something that still happens, although to a lesser degree now. And that may be a matter of custom, but when the legal rule is that when customs run counter to the plain and unambiguous language of a registration statute, the customs must give way to the law. So they, again, affirm the finding of gross negligence against the firm. The structural drawings did not communicate to the fabricator that it was to design the box beam hanger rod connection. They appear to be connections fully designed by Duncan, the structural engineer. The load calculations to allow the fabricator to design it were omitted. Even the type of weld of the box beam was omitted, and the need for bearing plates and stiffeners was omitted. So there was a lot that the structural engineering firms did not do that the court felt it had to do as part of its professional responsibility. Because no matter what, the adequacy of the connection design remains the responsibility of the engineer of record. You know, you can have contracts that shift liability for delegated design, but the contract or customary practice will not relieve an engineer of record or an architect of record from their professional responsibility. Gilliam tried to get out of it by saying that Duncan's gross negligence shouldn't be imputed to him, even though he was his boss and the structural engineer of record. But you know, the legal rule was because Gilliam affixed his seal to plans, he could not then disclaim responsibility after the fact. So they said he was vicariously liable for the act of Duncan. And, you know, there was also a criminal investigation during this time, but the started in 1983 for crimes of manslaughter and perjury and false declarations and criminal conspiracy. That was later closed. The court determined there was insufficient evidence to establish probable cause that the crimes were committed. This shook up the engineering community, as you can imagine. The engineering community really began an introspective look at what went wrong and how failures could be prevented in the future. The study by the National Bureau of Standards was headed by Ed Frang. Ed Frang was a civil engineer who then became executive director of the American Society of Civil Engineers. And he stated publicly that the engineer's shop drawing stamp used to provide a clear-cut statement that drawings were approved, disapproved, or approved with corrections, but that such stamps have been revised over the years to include long, vague statements, which he says were artfully put together by insurance companies and lawyers. And in fact, that was the case. One of our competitors at the time made a point of telling architects and engineers that if they simply put no exceptions taken on a shop drawing stamp, that they weren't accepting responsibility for it. And this case certainly proved that not to be true. If you have the duty to review a shop drawing stamp and you let the thing be built based on that, you've approved it, no matter what disclaimer language you may put in there. This also changed the AIA document significantly. The 1976 version that referred to shop drawing stamps was about a third of the length of the 1987 version. And the 1987 version had a lot of disclaimers, shall not, is not responsible, those kind of language provisions in it to try to keep the architect from being held responsible for failures in delegated design or actual construction. Now let's move on to the Carini case. This was influential in addressing the consequential damages. It really centers on the former Sands Hotel and Casino in Atlantic City. If you don't know Atlantic City, you know, it used to be a major resort area during Prohibition. It was the place where you could go to drink because Prohibition wasn't being enforced there. It started to decline one of the ways they tried to revive it in 1976 is to pass a law allowing casino gambling. The first casino was opened in 1978. And this one, which was at Brighton, built in 1980, became the Sands. The difference between Atlantic City and Las Vegas was Atlantic City tended to attract a lower level of gambler, and they wanted to attract high rollers. And this hotel wanted to become a high roller place. It, however, had no boardwalk access and did terribly in the first few years it was open. It was rescued by the owners of the Sands in Las Vegas. It was rebranded as the Sands Hotel. And even though it changed ownership a number of times, it stayed as the Sands Hotel. It finally became profitable in 1982. And the Sands realized that the hotel realized they had to change its image. So it came up with this new glitzy glass facade to lure customers off the boardwalk and into the casino. It was a $16.8 million addition. It was later raised to like $24 million. And Perini was hired as a construction manager. Perini agreed to a $600,000 fee. And one of the things of the construction of this new facade is the casino had to remain open because casinos are money makers when they're running successfully. They do not close their doors. The Sands informed Perini that it was critical that the change be completed by the summer so that they could take advantage of the high season for gamblers. And in fact, it said it would push the project a year farther down the line if it could not be completed by the summer season. Perini said they could meet the target of May 31st, 1984 as a substantial completion date. Here's a simple schedule to illustrate the key dates. Part of it was completed on time. The suites part of the hotel to upgrade it were not completed until mid-September, but that was covered under an extension. But the facade was not complete, and the boardwalk access was not complete. Sands filed a claim, and an arbitration panel awarded Sands $14.5 million in damages for lost profits. It also gave Perini $300,000 for its contract balance. Perini challenged the award in the New Jersey State Court. The lower courts affirmed the arbitration panel. Perini's argument was, look, if it had known that the gamble on this was $14.5 million, it would not have taken a job for a $600,000 fee. If it could have contemplated the damages for lost profits, if that wasn't mentioned in the contract, it had no idea it could be responsible for that. The Sands said, look, we agreed to a time. You knew how important it was to have the project open on time, and the lost profit damages were entirely foreseeable, and therefore Perini should have to make them whole. And the legal question was it a mistake for the arbitration panel to award those damages for lost profits because they were not discussed in the contract? The New Jersey Supreme Court actually went back to an 1854 case which talked about responsibility for both direct damages, those damages that arise naturally from the contract, and those damages that could be called consequential damages, which reasonably be supposed to have been in the contemplation of both parties at the time of the contract. And basically that is why Perini was held responsible. That even though it was not in the contract, you knew why you were doing this project. You knew the importance of having it open on time. This is not an unusual case. If you've ever designed a store that had to open for the Christmas shopping season, you know that if that store doesn't open, that store owner may in fact go bankrupt because they're losing so much money during the Christmas shopping season. And there's a number of other consequential damage cases like that that design professionals are held responsible for. But contractors certainly thought that was unfair. And the AI responded 20 years ago now in the 1997 documents with this kind of language. And it's been carried over to the 2007 and 2017 documents. And this is a waiver of claims for consequential damages. You know, contractors were shocked as they realized the level of unpredictability in consequential damages, and this addresses that. By waiving claims for consequential damages, the owner and a contractor really limit themselves to direct damages. And that supposedly eliminates some of the incentive to escalate claims and probably encourages settlement. And that's a clear negotiation point between contractors and owners. Both parties to a contract, construction contract, could have extensive consequential damages. To move this over to design contracts is a little bit different. The AIA included a similar provision because in the owner-architect agreement, partially because they thought if the owner waived consequential damages against the contractor, the owner would simply come after the architect for those same damages. So starting in 1997 and carried through the 2007 and 2017 with this language. That's a little bit different than what you see in the contractor's provision. It doesn't talk about liquidated damages because they are not common in a professional service contract. But what we have seen over the years is that few owners who understand what a consequential damage might be accept this language. And that's because architects really aren't waiving much when they waive their rights against the owner. But the owner is waiving a tremendous amount of damages if they waive consequential damages against an architect or an engineer. You know, the Perini case talked about the necessity for a waiver of consequential damages. We would like to see architects and engineers include such a waiver of consequential damages in their contracts, but that's not always feasible. And what happened to the sands? Well, you know, Las Vegas continued to decline. The building was demolished in 2007. It was the first casino hotel implosion on the East Coast. It was converted to a park, and then eventually became a parking lot. Okay, let's move on to the difficulties of condo exposures and, more importantly, the difficulties of California law. Mike?
All right, thanks, Frank. So if you've been keeping track, we've talked now about one case that's 100 years old and two cases that are several decades old. The next two cases that we are going to talk about are very new. The first one is Beacon Residential Community versus SOM. This is a case that we get from the California Supreme Court in just a few years ago in 2014. This is a case that has been discussed quite a bit over the last few years in construction law conferences and in continuing education courses. So this may be a bit familiar to some people out there. So let's set up this case and what this dispute was about. The Beacon is a nearly 600 unit development near AT&T Ballpark in San Francisco. The developer of this project hired SOM and HKS to provide architectural engineering services. And an important thing to remember here as we go farther on and explain this case is the developer actually rented these units as apartments for the first 2 years that they were built. And then, after they had been rented for a couple of years, they were then sold off to condos to individual homeowners. The agreement between the developer and SOM actually included a clause that stated that the agreement was between the two parties and that there were no third-party beneficiaries to that agreement. It's going to become important later on. Once these units were sold off to individual condo owners and a homeowners association was formed, years later, the Homeowners Association for Beacon actually filed a complaint against SOM and HKS for negligent design work Of course, this isn't a contractual claim. This is a tort-based negligent claim. And Beacon Homeowners Association alleged quite a few defects in the project, including water infiltration, structural cracks, and so on. Probably the most important claim in the minds of the residents was that during the summer months when you were living in your condo, it heated up to a point where you really could not get the units to cool down to a comfortable level. And the Beacon Homeowners Association alleged that the architect and the engineering team had approved cheap substandard windows and designed inadequate ventilation, contrary to building codes and contrary, presumably, to the architect's standard of care. So let's get to the positions of the respective parties. I mean, right off the bat, one of SOM's primary arguments was that there was no contract between them and the Beacon Homeowners Association. Imagine for a second that you are an architecture firm and you, like SOM, and you get served a complaint from Beacon Homeowners Association. You go looking through your files, and while you might see a project named Beacon, you don't see an agreement that you have with them. You have not provided this homeowner association with any services, and the argument became from SOM, listen, you bought this property from a developer. If you have a problem with the property, sue them. Another argument that SOM made was, the architect, they made the argument that they don't have a duty, a tort-based duty that was owed to the Beacon Homeowners Association. They argued that they owed a duty to their clients, which were the developer, but they don't owe a duty to the Beacon Homeowners Association. And then they also made the argument that, if future purchasers of a home or of a project that I design can sue me on a negligence tort-based theory, when does my liability end? I mean, I think most states have a statute of repose that will cut off claims at the 10-year mark or around there. But how many times can a project pass between different parties, all having a contract for purchase and sale of a condo or of a home? How many of those kind of transactions can happen and still have somebody come back and sue me as the architect of the project? On the other side, the Beacon Homeowners Association made a couple of arguments to support their claim. First, they made a comparison to the product's liability legal theories that, if you are a manufacturer of a product, of a toaster, of an oven, of something like that, you can't escape liability for harm to an end user simply because there were several changes of hands before it ended up in someone's home, simply because Sears or Best Buy sold that. And therefore, an architect is not a heck of a lot different than a manufacturer of a product, at least in the eyes of the Beacon Homeowners Association, that you are putting a building, you're putting a condo into the stream of commerce, and you should be responsible, at least owe a duty to the end users who end up living there. And they, of course, made the converse argument that SOM made, was that, yes, an architect does owe future homeowners or future purchasers of a project that is designed by that architect a tort-based negligence duty. It's foreseeable that people are going to be selling condos. It's foreseeable that somebody is going to, that condos are going to be changing hands, and the architect should be thinking not just about the immediate client, but about future purchasers of a condo or a home when they're doing their design work. So the California Supreme Court took all of this and gave us the rule that you see quoted on the screen. And quite simply, it is that an architect in California owes a duty of care to future homeowners in the design of a residential building. And this really, it probably did not come as a huge surprise to California architects that California courts will side with a homeowner's interests. This is a decision that is, at least on its face, limited to residential buildings. It, at least at this point, is limited to California. Because if you remember back to some of the first slides we talked about, This is a California Supreme Court, and all the courts under it have to follow this rule. Not necessarily, other states will look at it, but they don't have to follow it as a legal precedent. So, like I mentioned, this is a fairly new case, and we still don't know. We still have not seen, a lot of courts that have had to decide cases that are based on similar facts. And so we were still kind of waiting to see, how this case will be, whether or not it will be carried forward by other states, whether they will follow the same rationale, and how will this case and the reasoning behind it be expanded. One of the things that is pretty certain after reading this is if you are an architect in the state of California, you certainly, when you are designing a building, you should be thinking about, beyond your client's, your own client, because it is entirely possible that that client could be selling that property to somebody else, and they may allege that you have in some way defectively designed the building that they are living in. It's also kind of an open question as to how you manage risk on a California condo project, on California, and also on California residential projects. I know I used to work for a couple of architecture firms in Southern California back in the early 2000s. One of them entirely decided not to work on residential projects for these kinds of reasons, because these kinds of court decisions were, if not prevalent then, were certainly anticipated at that time. So something to keep track of in your own state is, will courts follow this California Beacon case in your state, and something to pay attention to as you're designing your buildings and as you're continuing to work on residential projects. And the last case that we're going to talk about is even more recent. This is a 2015 case from Maryland Federal District Court titled the Chesapeake Bay Foundation versus Weyerhaeuser. This is one of the first cases that we've really seen that tackles the questions about green buildings, and in particular green building products. And it focuses on one of the first LEED Platinum buildings that was certified by LEED. This case centers on a dispute about the Philip Merrill Environmental Center construction project that was finished in 2001. This is the headquarters of the Chesapeake Bay Foundation. Clark Construction was the general contractor on this one, and Smith Group was the architect. And the building itself was, frankly, pretty amazing from a design perspective, from an environmental design perspective. It featured composting toilets, geothermal heating and cooling, rainwater retention and reuse, and the use of low VOC emitting materials. So an incredibly environmentally friendly design aspiration here with this building. It's located just south of Annapolis in Maryland, right on the Chesapeake Bay. And those of you who live in this area will know that it can be a harsh weather environment. You're going to get snow, you're going to get heavy rains and storms, you're going to get pretty hot summers as well. And this building was right on the Chesapeake Bay, so it was certainly subjected to pretty harsh conditions from the time it was built. And important to this case was that much of the structure, both interior and exterior of this building, featured exposed paralam wood members. And these were supplied by Weyerhaeuser. And those of you who've ever done any work with wood construction, you know that it's very susceptible to moisture, and in particular, paralam members are even more susceptible to moisture than other wood products. So Weyerhaeuser hired a company named Permapost to apply a coating, a sealant coating, on the exterior members of these wood paralams. And that coating was named Polyclear 2000. And the attempt, of course, was for that to provide a weatherproof coating for the exterior members. Well, the building was finished in 2001. By the end of that year, and in 2002, there was leaks that were already starting to be evident, where water was penetrating into the wood, and penetrating into the building. And then there was significant rot on the exterior wood members that was evident by the late 2000s. So it was pretty clear that the attempts to weatherproof the exterior parallam members had failed pretty dramatically and pretty quickly. So one thing that makes this case different than the other ones that we've talked about is that we don't actually have a final opinion from a court. We have, like many construction disputes, this case was settled after there was some litigation, but we have a few opinions from a federal court that on motions that give us some clues as to what happened in this case, but we don't have a final opinion from a court. So we are guessing a little bit at the results of this case, which is pretty common, to be honest. So what do we know? Well, I'm going to actually back up a slide real quick. We know in the dispute, the Chesapeake Bay Foundation, Clark and Smith Group, we know that they entered into a settlement to remove and replace all exterior parallams. So a considerable amount of work and money to do that. They also filed suit then against Weyerhaeuser for $9.6 million. Weyerhaeuser settled their claims and then pursued Permapost in a separate action. So, everybody that touched this project was embroiled in some way in this dispute. We do know that, at least from reading the opinions that we are able to read, nobody got by completely unscathed. I mean, everybody was in some way involved in litigation. Most of the parties had to pay something. We might not know exactly how much, but certainly nobody got by on this one without feeling a little bit of pain. We also know that the Polyclear 2000 coating while it was a low VOC emitting material, it was also unproven for this particular application. It was something of an experimental material for applying to these exterior parallams. And if you read through the opinions that we do have access to, all the experts agreed that there were better coatings out there. And that's not really a surprise when it comes to environmentally friendly green materials. There's always going to be something out there that's probably better and has been around for 20 years. It just might not meet the kinds of criteria for your green, building codes or for your LEED rating systems. What do we not know? I mean, it's quite a lot that we don't know about this case. We don't know about the contracts between the parties. We have no idea if there was, if there were contracts between the architect and the owner that, described some of the responsibilities for and nuances of specifying green products and some of the hazards that can result from that. We don't know if Polyclear coating was inherently a product that would never have worked, or was it just applied improperly. And we don't know if Weyerhaeuser held itself out as having specialized knowledge about that coating, and if so, could the architect rely on such a representation by Weyerhaeuser, a supplier on the building. So that's a lot of questions about this case. Not a lot of answers, to be honest. But the good thing is that it's a little shameless self-promotion. The AIA does offer a lot of good materials to help you as design professionals navigate through sustainable projects and some of the new issues that we're seeing on those. In particular, I would recommend that anybody look at our D503-2013 Guide for Sustainable Projects. There's language in there that you can insert into your contracts that discusses things like untested materials and describes exactly the architect's responsibilities and the owner's acceptance of whatever those risks might be. I think now we're getting ready towards the end. If you have any questions about AIA documents or any kind of, we've mentioned several AIA documents throughout this program, but we do have a lot of good resources at the AIA. You can get onto our website at aia.org and click the link Contract Documents. We also have an email account, docinfo@aia.org, and a phone number you can call if you have content-related questions.
Okay, thank you.
So
right. As Mike says, there is information out there available from the AIA that the 503 is a great document to have in your library. You also can go to our website, the School of Risk Management, where we have, in fact, cautions on using untested products, which actually was first developed by us back in 1971, and is as true today as it was back in 1971. There's also information on sustainability issues, including informed consent language that you can tap. This webinar will be on our School of Risk Management as well as other information. And as a policyholder, you can get onto that website. You can sign up for it. You register for the website. It takes a day or so, and you can have access to all that information. So we thank you for attending this webinar, and there are a few questions which I will try to answer after this program. Because we are recording this, we're going to stop the recording at this point. And I thank you all for attending. Please don't forget we have another webinar next month. It will talk about risk management issues, risk mitigation issues. Judy Mendoza and I will be doing that program. So please sign up for that one. And thank you very much.